I think we are live streaming. So Steve, you want to take it from here?
Sure. I want to welcome everyone to the subcommittee. I want to thank David Allen for asking me to chair this subcommittee. The work we're about to do, I think, is essential and important. I think that the cast of characters I see in little boxes on my computer screen are all people that I respect and whose opinions I have listened to carefully and admired in the years that I've been involved with the bar. And it'll be my pleasure to serve with you. I need to start by asking if there are any conflicts of interest that anyone is aware of that would cause you to not be able to take part in this discussion today or to participate in the subcommittee proceedings or anything, any recusal is necessary. Hearing none. Okay, we'll begin then with, I suppose everyone's seen the outline and that this committee will begin its work by studying the constitutional issues and that may arise in terms of infringement of freedom of expression, freedom of speech, and that we'll look at what other states have done concerning the this language and our discussion here concerns the addition to Rule 8.4, and as probably everyone is aware, there was anti-discrimination language recommended to the Supreme Court some years ago to be included in the preamble, and I think we have a separate group studying that. Is that right, Brian?
Yes, that's correct.
So what our job is to do is to begin by studying what is the constitutional impact, what have other states done, is this something that we want to consider putting in Rule 8.4, and I know that Brian and Carmen have done some footwork, some legwork, so to speak, to get us a foundation in that regard. So I'm sure they're prepared with the presentation today that'll kick us off. So I'll turn it over to you, Brian, unless there's anything else you need from me at this point.
No, I think that's great. Thank you, Steve. I'm going to share my screen here. And like Steve said, Carmen and I are going to essentially make a presentation today as we begin this discussion, as we begin this analysis of this particular issue. Just to be sure that everyone's on the same page, and I know we've had a number of folks that I guess both within the council and outside the council that have called with questions about exactly what is going on, what's the status of these different proposals and so forth. And so I just want to recap and make sure we're all on the same page. As Steve just mentioned, we do have a proposed amendment to the preamble that is currently published at the July meeting, the July State Bar Council meeting. The Ethics Committee and followed by the State Bar Council recommended for publication an amendment to the preamble. That amendment really was some language that identified the avoidance of discriminatory conduct while acting in a professional capacity as a fundamental value of the profession. Now, of course, the preamble is aspirational. It is not something that is necessarily enforced in disciplinary actions. But I guess as we looked at these different proposals or different things that other states have done, the preamble was brought up once again, just out of the general thought that, like Steve said, it was previously approved by the State Bar Council in 2010, but it was not subsequently adopted by the Supreme Court. So that was kind of a reintroduction of the preamble. But in addition to that that action, the Ethics Committee created these two subcommittees. This subcommittee, which is studying the inclusion of anti-discrimination language in the actual rules of professional conduct. That would be an actual rule that's enforceable for disciplinary purposes. And then the second subcommittee was created studying the inclusion of a new comment to Rule 1.1 regarding a lawyer's competency, and that competency encompasses a lawyer's awareness of implicit bias and cultural differences. So this subcommittee and that subcommittee are currently active in this quarter. For those that are wondering, that second subcommittee concerning the competency comment, they are scheduled to meet on Wednesday, September 23rd at 2 p.m. So we will be live streaming that one as well. But our focus in this subcommittee is this second bullet point: the proposed study of inclusion of anti-discrimination language in the rules of professional conduct. And of course, this is the one that I think has probably brought about the most response from a number of different individuals that are both supportive and that oppose inclusion of this type of language in the rules of professional conduct. As far as this particular proposal, just a quick intro, and this material was included both in your materials for today's meeting, as well as the ethics agenda back in July for the Ethics Committee. As of June of 2020, 37 of 51 United States jurisdictions, and that includes the District of Columbia, have adopted some type of non-discrimination language into their rules of professional conduct. 28 have adopted language into their actual rules, the text of their rules, and 9 have adopted language solely as a comment to Rule 8.4. Basically, they typically focus on 8.4D, which says that it's professional misconduct to engage in conduct that's prejudicial to the administration of justice. And they added a comment that essentially says that kind of encompassed in that particular rule would be discriminatory acts. Discriminatory acts would be prejudicial to the administration of justice. Now, that's not to say that all states have taken action in adopting. A number of states have looked at these proposals, particularly the ABA's model rule 8.4G, and they have rejected it, including Texas, Louisiana, Tennessee, and South Carolina, just to name a few. Texas did something different, though. Texas actually does have some anti-discrimination language in the text of their rules, but they put it in a different section of the rules, and it kind of has a different flavor. And we're going to get into that in a couple of meetings. But South Carolina and Tennessee ended up adopting a comment to their rules. And South Carolina, from what I understand, is actually reconsidering the adoption of anti-discrimination language into the text of their rules as well. So I'm trying to stay in touch with their bar counsel to understand the status of that, and we'll give you guys updates as things progress, if they do progress. I talked with Steve after David appointed Steve, and we kind of talked about how do we want to approach this particular issue. And we came up with this kind of three-phase approach. The first phase being information and education. And that is I guess the idea, of course, is to look not necessarily at how we got here and perhaps the different things that maybe inspire us to either recommend adoption or recommend rejection of anti-discrimination language, but to really just educate ourselves first and foremost. What are the constitutional concerns? What's the constitutional framework for regulating lawyers and adopting rules of professional conduct? What are the disciplinary or the enforcement concerns, including what disciplinary cases have been brought in the time that these various states have enacted these types of rules? And this stretches back for a while. From what I can tell, and I haven't gotten the list fully complete yet, but I know Colorado, for example, has had anti-discrimination language in their rules since the mid-90s. So it's not like there's just a plethora of cases out there, but there are a lot of cases dealing with this type of conduct that we can learn from and see exactly how those disciplinary cases played out. And then to look at what are the other states doing? What language choices did they make Did they follow something like the model rule, or did they come up with something entirely their own? And understanding what they did in the framework or with the constitutional background that we're going to discuss, we're going to focus on here today. I think it'll be very educational for us to understand why certain words have been chosen over others if something was actually adopted. But then after we get through the information and educational stage, then we want to move on to this next phase, which is essentially a building exercise, almost consider it an academic exercise. Knowing what we know about the concerns, constitutional, disciplinary, enforcement, and so forth, all the stuff that we learned in this first phase, is it even possible to draft a rule that satisfies those concerns, or at least closely satisfies? Or do we find that it's completely impossible? If we get to that point and we end up drafting something, I think after we get through those first two stages, then we reach that third phase of, okay, if we were able to draft satisfactory language, well, then what should we do about this? Should we adopt this language that we have analyzed and determined is satisfactory for all the different concerns that we have and that others have? Should that be adopted into the rules of professional conduct? So that's the approach that we're going to take with this. I don't expect that we will be done in a month or anything like that. We're going to have a number of meetings and talk about this, but I think this is a very important issue. It's a very delicate issue, and I think it's deserving of a thorough explanation by this committee. Questions that we feel like we need to answer, and this is just a sample of questions. I'm sure you all have a number of questions that you would probably like to answer as well. But just some of the things that we've kind of kicked around are questions like, well, what conduct do we seek to prohibit? What exactly are we trying to address through this rule? Can the state bar draft this rule at all, again, while satisfying these different constitutional concerns? What level of specificity do we need to employ if we're going to draft something? What's the relationship between this rule and the regulation of the legal profession and the improvement overall of legal services? And where would this rule be placed? Again, just as a preview, the states that have adopted something have placed their rules mostly in 8.4, but a number of states have incorporated language into rules such as Rule 4.4, which addresses a lawyer's requirement to not engage in conduct that has no other substantial purpose other than to embarrass, burden, or harass somebody. So there have been some kind of creative and different approaches from the other states, and we're going to take a look at that. And ultimately, how is the state bar planning to enforce some type of anti-discrimination, anti-harassment rule? There's going to be a lot of discussion there of, how exactly is the Office of Counsel supposed to respond to a complaint? What complaints are going to need to be really dug into in exploring the allegation of misconduct that's contained in the complaint. So again, there's probably just a number of other questions that we will want to answer during this process, but this is kind of where we want to start our thought process and start getting into this exploration of whether or not anti-discrimination language should be in the rules of professional conduct here in North Carolina. So what we wanted to start off with here, like I said, Carmen and I wanted to go through the constitutional concerns regarding anti-discrimination language and the different things that we have seen in doing our own research. Carmen was kind of appointed by Catherine Jean to be our liaison from the Office of Counsel, because of course the Office of Counsel would ultimately be the part of the bar that would need to put their hands on the allegations stemming from this type of prohibited conduct, or I guess what's proposed to be prohibited conduct, and how the Office of Counsel would deal with that and how they would view it is very important. But also the Office of Counsel is really the state bar's lawyers. They are the ones that step in when we get sued in federal court or in state court. And so there's a number of different considerations that the members of our Office of Counsel play around with and really try to absorb in terms of protecting the state bar and ensuring that everything the state bar does is in fact constitutional, it's justifiable, and something that is just ultimately going to be valid. So with that said, Carmen, do you want to step in here and start with our introduction?
I would be delighted to, Brian. Thank you. And actually, before I say anything else, I just wanted to make sure that we greet and acknowledge Liza Foley, who is the newest lawyer in the Office of Counsel, who has been working with Brian and me on this project. And I think probably with the screen up, the only way anyone's going to see you, Liza, is if you unmute and say hello. So I just didn't want this meeting to go by without thanking Liza for being on this journey with us.
Welcome, Liza.
Thank you. Happy to be here.
Thanks, Liza. I will also say that Brian and I were on the inaugural editorial board of the First Amendment Law Review at UNC Law, and so it was incredibly difficult for us to try to do this in a digestible way for all of you. It's a miracle we're not both still down a Lexis rabbit hole till the end of time. So we've done our best. As you saw from the materials that were distributed, there's a memorandum that is a summary of what we believe to be the primary constitutional issues that any study committee needs to be aware of in crafting any rule of professional conduct, but perhaps even more so one of the nature that's being contemplated here. So the presentation today will essentially track the outline, will follow the structure of the memorandum that was in your materials. Also in your materials were some of the documents referenced in the memorandum. We included the law review articles, of a collection of opinion letters that were issued by attorneys general and some other interested parties in other states. And so we gave you those. We did not give you all of the cases because we thought probably 200 and some pages was plenty. And if you wanted to review case law, you will be able to do that on your own. So today we're just going to go through those topics in the memorandum, starting with a discussion of Keller v. State Bar of California, which is a general analysis of the ways in which mandatory bar membership implicate First Amendment concerns. And I prefer pictures to text, so that's what you're getting right now on the screen. Essentially, the issue that was analyzed in Keller is the fact that in order to be members of the profession, lawyers are required by law to be a member of the state bar and to pay mandatory dues to the state bar. So that implicates the membership itself, implicates the freedom of association protected by the First Amendment, and the payment of mandatory dues to finance bar activities can implicate the freedom of speech in that mandatory membership dues are used to subsidize speech by the state bar. And I've just included in this visual some of the ways in which the state bar engages in expressive activity or speech. The regulations we have on what sorts of CLEs will be accredited, or what are appropriate topics for accredited CLEs. The publication of the journal is a pretty traditional form of speech. We have a registered agency liaison who engages in lobbying type communications with the legislature. So lobbying is a form of speech. Even it occurred to me that last year we had the opioid summit. That was a decision about the type of content that the state bar was going to promote and sponsor within the agency. We have social media accounts, etc. So the question in Keller was, to what extent are lawyers who are required to pay dues obligated to subsidize speech that they don't agree with? That was the core question. And the answer to that question turned fundamentally on whether the speech that the state bar engages in is germane to the core functions of the state bar. And so we're going to talk a little bit more about Keller and explain in what way it might be relevant to this subcommittee's study. So Brian, if you would go to our next slide here. This is the basic standard that was actually in this instance articulated in a follow-up case to Keller a few years later. But the basic rule in terms of what's a permissible use of a compelled subsidy like dues is that it must serve a compelling state interest, and whatever activity is funded with those dues must serve that interest in a way that is could not be accomplished in a significantly less restrictive way. In other words, it's got to be closely tailored to the advancement of the state interest. All right, Brian, let's move on. Yep. Okay. Now there have not been all that many decisions specifically addressing the application of this Keller standard to things that state bars do, and the activities of state bars throughout the country are pretty varied. We have a few appellate court decisions that have placed some state bar activities on one or the other ends of the spectrum of whether or not it is these activities are appropriate use of mandatory dues. The way that the general principle articulated in Keller is that it's fine to use dues for purposes that are necessarily or reasonably incurred for the purpose of, and then they gave these two purposes, regulating the legal profession or improving the quality of legal service available to the people of the state. And in applying that standard, the courts have said, lobbying on things that are really unrelated to the functioning of the courts, the licensing and competence of professionals, things like that, that's not an appropriate use of mandatory dues. Also, any kind of publication or promotion of material that is primarily political or ideological in nature, that's not an appropriate use of the dues that lawyers are required to pay. Now, on the other end of the spectrum, courts have acknowledged that there are issues on which a state bar might lobby that are tightly related to the purposes of the state bar. Those things are going to be permissible. A couple of different bars in different states have actually paid for public relations campaigns. Unfortunately, that's where we've arrived as a profession. They paid for things that were designed to improve public trust and confidence in lawyers, and that has been deemed a permissible use of dues. CLE programming in general is considered part of the core functions and therefore an appropriate use of dues. And access to justice programs have also been endorsed by the courts as something that we may do with compelled membership dues. There was a recent decision mentioned in the memo that I think is particularly germane to this subcommittee's work. I didn't include it on the visual because it's not an appellate court decision, but a district court in Texas addressed a Keller-related challenge to a variety of Texas bar programs, including their diversity initiatives. And the U.S. District Court there said that those initiatives seek to reduce barriers and promote fairness and equity among lawyers, to help build and maintain public trust in the legal profession and the judicial process, thereby advancing interest in professional regulation and improving the quality of legal services. So that, at least that district court seemed to find a close nexus between diversity initiatives and the permissible use of dues articulated in Keller. All right, Brian, let's move on now. This is just a quote from the Keller decision, reminding us that there are a lot of gray areas perhaps in the middle of the spectrum that have yet to be addressed or fleshed out and may not be. The court essentially saying it is clearly not okay for a state bar to use dues money to advocate on controversial political issues. They give as examples gun control, nuclear weapons proliferation, that sort of thing. And then they say on the other end of the spectrum is things that are absolutely central and core to state bar function. And as an example, activities connected with disciplining members of the profession and proposing ethical codes. So with respect to the promulgation of a rule of professional conduct as a standalone activity, which is what this subcommittee is fundamentally charged with doing, that seems to fall pretty squarely within the core appropriate uses of dues for state bars. Just one more slide here on conclusion on Keller. As I just said, it seems very unlikely that any court would say that promulgating and enforcing a rule of professional conduct wasn't exactly the sort of expressive activity, if you will, that it should be funded with lawyers' dues. And the fact that it is certainly possible that, particularly with a rule of the type that we're discussing here, that it could be characterized as having some political or ideological coloration to it. And what I would emphasize there is that Keller did not place a per se ban on anything that might arguably have some ideological bent. What it said is that we can't do things that are purely political or ideological, which makes sense as a government agency, but things that are related to the core mission of the state bar, even if they have some political or ideological component, that doesn't make them an impermissible use of dues. So that is the overview of what Keller says. And unless, Brian, I've forgotten to say something, I think we can move on to the slightly more exciting due process concerns.
All right, and that's where Carmen and I are going to, I guess, trade off a little bit as we go through this, hopefully just to keep your attention, but to also just kind of, I guess, be able to explore all these things that we're looking at as far as these constitutional concerns. And I just want to kind of point out that these concerns that we've highlighted are the ones that, yes, we've been doing our own research into these issues and just trying to anticipate what challenges might come, but we really are influenced by the points that have been raised by a number of these, whether the state's attorneys general that have filed their different objections to Model Rule 8.4G in their particular jurisdiction, or some of the feedback that we've already received from members of the bar about these proposals. You know, although we don't have a particular proposal on the table, just the study proposal has generated some response both in opposition and in support. But we wanted to kind of go through and just identify these different concerns. But I just want to also let you know that we're basing these concerns and kind of the identification of these concerns on the materials that we have that we've already received. So the next one that we want to talk about is due process and vagueness. And I think that's one of those things we remember back in constitutional law, void for vagueness and overbreath and all that kind of stuff. And, vagueness is really a due process issue. That when something is vague, then the person who is, whether they're charged with a crime or they are subject to some sort of discipline, whatever government regulation is being imposed, if it is a vague law, then essentially that person is deprived of due process because they do not know what it is that was prohibited. A vague law means that prohibitions are not clearly defined, and it doesn't give a person of ordinary intelligence this opportunity to know what is actually prohibited. Of course, as we've seen through a variety of cases and, kind of these flashbacks to con law, remembering the different cases that you studied in this vagueness category, that, a lot of times these vague laws would lead to arbitrary enforcement and even discriminatory enforcement by failing to provide these explicit standards that everyone could identify, everyone being both the public that was subject to those standards as well as those that are enforcing them. And particularly with regards to this, since we're talking about a rule that would impacts speech. Vagueness allegations, the courts have been very clear, vagueness allegations on restrictions of speech are rigorously scrutinized. It is something that is kind of, I guess, catches the court's attention that much more. And really, you need to have kind of a heightened standard in terms of identifying whether or not a law is actually sufficiently defined and is not void for vagueness. But, I think as we were looking through our current rules, and looking through the different scholarly articles and the different letters that have been submitted, it strikes us that there are existing rules of professional conduct that do employ imprecise terms. We have Rule 8.4 that prohibits lawyers from engaging in conduct that's prejudicial to the administration of justice. Lawyers are prohibited from engaging in means that have no substantial purpose other than to embarrass, delay, or burden a third person. Rule 3.5 talks about or prohibits undignified and discourteous conduct towards the tribunal. And those sorts of those different rules have been challenged over the years. And that was something that I have to say I found myself being quite educated on, seeing the different challenges that have come through with regards to our current rules. You've gotten the memo, a couple of different cases from different states or federal jurisdictions where folks have challenged that. And really what the courts seem to kind of focus on is that context for the rule or context for the terms, what is being prohibited is really key. You can see here in this Fifth Circuit case that came out of Texas, somebody had challenged the State Bar of Texas because they had been disciplined for engaging in conduct that's prejudicial to the administration of justice. And this individual challenged that and said that rule is void. It's void for vagueness because it's not specifically defined. And the Fifth Circuit came back noting that the traditional test for vagueness and regulatory prohibitions is whether they are set out in terms that the ordinary person exercising ordinary common sense can sufficiently understand and comply with, without sacrifice to the public interest. The particular context in which a regulation is promulgated, therefore, is all important. And ultimately, the court upheld Rule 8.4D, upheld the prohibition on conduct that's prejudicial to the administration of justice. And notably, I think the court provided some good guidance here as far as what are we looking at if the State Bar in North Carolina is to craft a rule that addresses discrimination or harassment the way that a number of other states have already done, that we need to pay close attention to make sure that the rule is specific enough to not be void for vagueness. That essentially, and some of these scholarly articles that we provided in your packet talk about this and talk about how discrimination and harassment without further definition very well are vague. And I know that's some of the feedback that we've received from folks that have written in opposing these different proposals, particularly any sort of adoption of model rule 8.4G, just saying that, what exactly constitutes discrimination? What constitutes harassment? And I think we've seen, and we'll get to this again in a couple of sessions, but looking at how other states have gone about this, a number of states have gone and defined, some have defined discrimination and harassment in the text following, maybe subparagraphs following the particular rule. But the point is just that in drafting anything, if we are to draft something that would be constitutionally sustainable, it needs to be precise. Otherwise, it could be void for vagueness. It needs to provide adequate notice to the lawyers of North Carolina what exactly is prohibited. But these terms, discrimination and harassment, aren't just kind of, automatic non-starters. You can look at Title VII. Title VII has been challenged, and Title VII still exists, of course, because they define discrimination and harassment. One of the articles, law review articles that we provided, noted that identifying the victim of the prohibited conduct may be necessary to avoid a vagueness challenge. That, in other words, you'll see some of these different rules and the different iterations of anti-discrimination rules and how they focus on prohibiting conduct in general, as opposed to prohibiting discriminatory conduct towards an individual. And so that's something that I think is kind of good food for thought for this committee as we consider whether or not there is a constitutionally permissible way to address discriminatory acts and harassing acts in the rules of professional conduct, that perhaps it would be necessary to identify a particular individual associated with the purported misconduct, as opposed to just having a very broad definition. With that said, Carmen, do you want to go into our fun topic of free speech?
The most fun, yes. And one thing I meant to say at the outset, but I'll say it now since I have the mic again, is that I want to urge this committee not to focus on the question of if we were to adopt this language, will the state bar be sued? I don't think that's the right question, because going into my 15th year in the Office of Counsel, I can tell you from personal experience that if you have someone who is motivated and unhappy with something that you've done as an agency or a state actor, you'll get sued. That's not really the question. The question is whether there are meritorious facial challenges to versions of this rule that we might decide to adopt. So I would just urge you to frame the question that way. As a global concept, attorneys' speech can be and is constitutionally restricted in ways that a non-lawyer speech is not restricted. And the Supreme Court has acknowledged that repeatedly in cases over many decades. And these are just a couple of quotes on the screen that explain in broad strokes the justification for why, as incident to the privilege of practicing law, lawyers agree tacitly to certain limitations on speech. And the decisions of the court are focused on the fact that lawyers are integral to the administration of justice. Their conduct and their speech is determinative in a lot of instances of how the judicial process operates. And therefore, the government clearly has a compelling interest in protecting that process. And if protecting that process means regulating the speech of lawyers, that's okay. So that's where we start as a broad concept. And that's not to say that state bars are free to limit lawyer speech in whatever way they might choose. We have seen the rules of professional conduct take shape over decades based on constitutional principles that have been developed as they were challenged. For example, our advertising rules. I mean, before Bates in the late 70s, there was no lawyer advertising, and Bates and subsequent decisions have fleshed out the constitutional parameters of limitations on attorney advertising, and our rules now reflect those constitutional parameters. The same is true for the trial publicity rule. You know, we had the Gentile case where a piece of that rule was challenged as void for vagueness, and the court articulated what is an appropriate amount of regulation on lawyer speech about a pending case, and now the rule reflects that constitutional limitation. Same thing with our rule on what sort of comments lawyers can make about judges. That rule has a standard taken directly from New York Times v. Sullivan about speech on public figures. And so it's not that there is unlimited ability to regulate lawyer speech. I don't want to suggest that, but there is a lot of latitude. And so if we go on to the next slide, I just want to make sure that before we dive into the potential challenges to the rule that is being studied, which could make it sound like this is impossible. We can't possibly do this. I really want to make sure that we are properly oriented to the amount of restriction on lawyer speech that already exists. So I start with rules that explicitly regulate and restrict what lawyers can say, what they can express. And there are all of these examples on your screen from, things about advertising and trial publicity, like I just mentioned, to perhaps the most restrictive rule when it comes to speech, confidentiality. And we don't suppose that any lawyer would successfully be able to challenge the confidentiality rule on the grounds that it limits free speech, because it is deeply understood that without the confidentiality rule, the adversarial system breaks down completely. So I want to make sure that we have that in mind, that it is not even remotely unusual or novel for the rules of professional conduct to restrict lawyer speech. Let's look at the next set are some rules that actually have the effect of compelling speech. So this is the inverse proposition, but still has similar First Amendment implications. So requirements about communicating with clients, about disclosing adverse authority, about reporting misconduct or misappropriation. All of these rules are in effect such that a lawyer can receive professional discipline for not speaking. So we have that aspect of our rules already in existence also. And then on the next slide, I wanted to point out some of the rules that Brian mentioned in his discussion of vagueness, which are rules that prohibit, by their terms, prohibit conduct. But in application, that conduct is often manifest in the form of speech. So I've given just a few examples under each of these rules of the kind of expressive activity that may result in discipline under these rules. So I won't read the rules to you again, but as you can see, things like the way a lawyer speaks, any kind of abusive, derisive, harassing type of commentary, threats and intimidation, and various other kinds of expressive activity are all already regulated under existing rules. And these rules have been challenged not only on vagueness, but also on other types of constitutional claims, and still they stand. I really think that for purposes of this subcommittee's consideration of what is possible when it comes to an anti-discrimination rule, that the most important existing rule to think about and compare to is the rule that prohibits using means that have no substantial purpose other than to embarrass or burden a third party. I think that one is probably the most analogous of the existing rules, and I would urge you to focus on that when you're considering the feasibility of this. And then I just have one more little conclusion to our overview on attorney regulation and free speech, which is to generally say that free speech challenges, both facial challenges and as applied challenges brought against the existing rules of professional conduct, are generally unsuccessful. You can find many, many, many cases of courts saying this is not a violation of your constitutional rights for you to receive discipline or for you to be subject to this rule. So that's that is what you see when you look at the case law as a whole. I've given you a quote from our Court of Appeals just because this case is close to my heart. But it is a fairly general statement that is not uncommon among appellate courts, saying, the First Amendment doesn't immunize attorneys from discipline simply because their prohibited conduct involves expressive activity, and reminds us that free speech is not absolute. So I think that is an important framework to go into some of the more specific criticisms that may be faced by an anti-discrimination rule. And I will just note that the general tenor and themes in cases where there are constitutional or free speech challenges to both lawyer regulation and judicial regulation, the tenor of those decisions seems to be that the state is going to be given leeway to regulate these players in the administration of justice, because society depends on public confidence in and willingness to abide by the decisions of the courts. And if actions by these integral players undermine that confidence, we could have a serious problem on our hands. And it's never articulated in quite that specific language in the court decisions, but that does seem to be the tenor of the way the courts will reject free speech challenges to judicial and legal regulation. And now we'll go to Brian for some discussion of the notion of overbreath.
Right, and that's as we go through this, remember we've hit the Keller concerns, the vagueness concerns, free speech concerns. And all of these are concerns that I guess our purpose here is to highlight what the concern could be, how courts have kind of reacted to these different challenges, at least to the extent that something has gone up through the courts, but then also just to keep in mind as we go forward with our study, just what sort of hurdles and real hurdles that we would have to, I guess, get over if we are going to actually proceed with some type of rule or in trying to draft some type of rule. It's not to, again, presume that some rule absolutely exists out there, but that can be drafted. But at the same time, it's just this general kind of question that we have of, in light of all these different challenges, we need to be aware of exactly what the challenge is, what the concern is, if we are going to draft something or even attempt to consider this in a way that's going to be justifiable and certainly constitutional. So overbreath is another concern that's been highlighted by a number of individuals that have written in, or folks in their scholarly articles, or the attorney generals. The overbreath concern really focuses on the regulation hitting too much conduct, too much protected conduct, that essentially, you're thinking of trying to really hit on this one particular type of conduct, but you do so by really putting a too broad of a rule that ends up prohibiting what ordinarily would be protected speech in this particular scenario. And I think that's something that that I think the courts are particularly keen on, as far as the regulation of speech and versus the regulation of conduct. That they are going to look very closely at speech regulations. But the big thing is that just because, I think for overbreath, just as this again cursory reminder, when we get to overbroad laws, the concern is not necessarily, does this law affect some amount of otherwise protected speech? And if it does, it's therefore overbroad. Now, the courts have articulated that for a law to be held unconstitutional for being overbroad, that it needs to impact a substantial amount of protected speech. That it can't just be a little pocket that was kind of unfortunately hit by this law, but that a substantial amount of protected speech must be covered for a law to be struck down for overbreath. So I think that's really the question that we have to answer within this committee. How much protected speech will this rule restrain in comparison to the unprotected activity that's sought to be prohibited or regulated? And I think this is where that question comes in that we talked about at the outset. What conduct are we seeking to prohibit with this particular rule? What are we trying to address? Because it would be, I'm sure we can articulate a number of very specific things once we get to that question. But that's where I think the biggest concerns have been articulated with something like, I'll just use again, Model Rule 8.4G. A lot of folks have been concerned with the overbreath of that particular rule, because it does encompass a great deal of speech that may actually be protected. And that's where I think we could be wise to, in drafting something and evaluating what are we trying to address here, to try to put parameters on that and make sure that the language really only addresses that which we feel is necessary to address for the purpose of improving legal services in North Carolina. Content-based regulations of speech. You see, I gave all the hard stuff to Carmen and the fun stuff to Carmen. So Carmen, you take it away.
So just narrowing down the focus on free speech concerns, content-based regulations, as indicated here in the visual, are treated with more skepticism by the courts than a content neutral prohibition, you know, like say a time, place, and manner restriction of speech, something that has to do with the actual subject matter being discussed, is always going to be viewed with a little bit more critical eye, because it starts to raise questions about censorship. So that's something that has to be addressed in any regulation, and perhaps particularly in one where it clearly does circumscribe a certain subject matter, a certain type of content, and that is the case for the types of anti-discrimination rules that we are going to be looking at. So let's go on and dig a little bit deeper into this. Now, what is interesting is that regulations that are considered content-based in their limitations on speech are, as indicated, subject to strict scrutiny, but there are also instances where the court has said, well, yes, this regulation on its face addresses a particular type of speech, but we're going to treat it for purposes of scrutiny as content neutral. So we're going to not require it to satisfy strict scrutiny. It can satisfy some lesser level of constitutional scrutiny if what it really is aimed at is the secondary effects of the speech that's limited. So I have as examples here cases, zoning ordinances that regulated where adult movie theaters could be, clearly targeting a specific type of content of speech, but the purpose of the regulation was to avoid or the secondary effects on the community. Neighborhood blight is not a very specific term, but that's a term the court used. Also, there's been a case where a state law school's policy that every student group that wanted to be officially recognized was required to accept everyone who wanted to join. And there were student groups who challenged that, saying, you know, you will dilute our expressive message if we're required to admit people who are not members of our faith or not otherwise affiliated with whatever the purpose of the group is. And the court said, no, that's actually not it. You can couch that as content-based, but it really has to do with the law school targeting the secondary effects of having exclusionary groups that are recognized and endorsed by the university. So that is, I think, a really important consideration in crafting an anti-discrimination rule, is what secondary effects may be created by the type of conduct that the rule prohibits. And in thinking about that, we have to then address the second carve out, which is that a content-based regulation where the justification for regulating that content is the effect it will have on the listener, that is not given the wider berth, the more lenient level of scrutiny that a secondary effects type analysis would afford. So if the purpose of the rule is to prevent an adverse reaction from a listener, that doesn't count as a secondary effect, essentially, the court has said. And so you go back into the category of regulations that are going to be subject to strict scrutiny. And a couple of the examples here that have come to the Supreme Court are a prohibition on displaying symbols of hate in public places. And the government justification for that was to prevent victimization of people who were vulnerable due to historical discriminatory treatment. And the court said, no, that's not really a secondary effect. That's just the effect on the listener. And there was a similar analysis in a case that banned denigrating foreign governments on picket signs outside of embassies in DC. And the court said just protecting the feelings and dignity of embassy officials that's not a secondary effect. So this is a really interesting analysis that I think will be important in discussing and formulating the way a rule prohibiting discrimination would need to be crafted and targeted. Let's look now at viewpoint discrimination, which is treated separately as a subcategory of content-based regulation of speech. And the distinction really is that content-based regulation just has to do with the subject matter, but viewpoint discrimination is a prohibition on having a particular opinion about a certain subject matter. And that is probably the most suspect type of speech regulation identified in the constitutional jurisprudence. As you can see from this quote from the Rosenberger case, the court calling viewpoint discrimination as an egregious form of content discrimination and directing state actors to abstain from regulating speech in a way that targets a particular opinion or ideology. So this is definitely, I think, a significant consideration in crafting any rule that will be robust in the face of a constitutional challenge. Let's look at the next slide on some of the ways in which this has specifically been applied to anti-discrimination rules. The threshold question, I guess, is it viewpoint discrimination to prohibit conduct that exhibits bias or discrimination against particular groups? And I think we can say as a general matter, no, not necessarily. We have existing laws, including the Civil Rights Act, that create penalties and consequences for exhibiting bias and discrimination. So it's not that simple. The analysis is not that simple to say that anything that prohibits discriminatory conduct is targeting a viewpoint and therefore is never going to survive. The second and more specific point raised by particularly some of the academics who have looked at this, is they noted that when the ABA promulgated the model rule, they included in the commentary this language, this proviso that was designed, well, I mean, wasn't designed to, it's what it does, specifically exclude from the application of the rule conduct by lawyers that is intended to provide positive treatment to the protected classes that are identified in the rule. And what it does then is create this stark and explicit contrast between speech in favor of promoting diversity, promoting underrepresented or undersupported groups, and speech that does the opposite of that. So it seems like that comment may create more questions about viewpoint discrimination than are necessary. So I think the committee should definitely consider what type of commentary would be appropriate in such a rule. And then just a couple of concluding remarks about viewpoint discrimination for the subcommittee going forward. The study needs to be shaped around the notion that speech cannot be banned on the grounds that it the purpose of the rules of professional conduct is so much more complex and significant than just prohibiting things that are offensive, that I don't think that will be a problem, but that has to really guide the discussion. And the subcommittee needs to look at and contemplate what are the secondary effects of the type of conduct that would be prohibited by such a rule. What effects are there on the public, on the administration of justice, on the profession? And then also really be mindful of not discriminating on the basis of viewpoint. And I think that will probably need to involve studying existing statutes and other regulations that have withstood constitutional scrutiny, despite the fact that they clearly provide penalty for a particular action or comment that evidences discrimination. So those would be the recommendations regarding viewpoint discrimination. And now we, I think, have concluded our brief didactic on free speech, and we will go to free exercise.
So one of the other things that's been brought up in a variety of articles and letters is that a rule that would prohibit a lawyer from engaging in discriminatory conduct would be an impermissible burden on that individual's religious freedom. And so, just again, as that general reminder, as far as our First Amendment jurisprudence, government regulations cannot be hostile to the religious beliefs of citizens. That, essentially, if you do have some sort of burden on that free exercise, you are going to have to deal with this constitutional scrutiny. But of course, free exercise does not necessarily relieve a citizen from complying with what's considered a neutral law of general applicability, even if that law prescribes conduct that the person's religion proscribes, or vice versa, if it proscribes conduct that the person's religion prescribes. So it's all kind of, I think, as far as the challenges that have been articulated thus far, I will say, based on kind of the survey that we have at this point, it seems like most of the challenges are on vagueness. They are on free speech, particularly content or viewpoint discrimination. But there's, I think, the free exercise component is one of those that the model rule tried to address, and I think our proposed language to the preamble tried to address as well. These challenges typically do focus, like the challenges and the objections that have been noted to Model Rule 8.4G, they tend to focus on discriminatory conduct against individuals that are based upon sexual orientation or gender identity. The Supreme Court, however, has held that protection from discrimination on these bases in public accommodations was within the state's authority, and that it did not violate the First or 14th Amendments. That was a case noted in the memo from I believe 1995. But then a recent Supreme Court case, the Bostick case, that just was the opinion was just released earlier this year, while expressly not addressing the free exercise issues. And I think that is an important thing. The case, they specifically said we're not addressing free exercise, but they nevertheless did find or did hold that an employer who fires an individual for being homosexual or transgender has discriminated against that individual in violation of Title VII of the Civil Rights Act. So there's at least an indication, if not kind of a demonstration by the court that essentially, laws that protect individuals from discrimination, it cannot be held invalid because it would otherwise infringe someone's free exercise of their religion. The language, like I said, the language of the model rule 8.4G, as well as our proposed amendment to the preamble, and even other jurisdictions that are out there, try to address those concerns by expressly stating that lawyers do not lose their ability to accept, decline, or terminate representation as a result of the rule. That essentially lawyers have the freedom to reject a representation and not be held accountable under the rule. Arguably, that is already in effect, because that person, if somebody is so morally opposed to representing somebody who has walked in their door, then that lawyer likely already has a personal interest conflict under 1.7 and should decline the representation anyway. But nevertheless, these rules that have been crafted and adopted by the different jurisdictions, including the model rule, try to carve that out in particular. Lawyers are also, in some of this language you see, lawyers not prohibited from offering advice or engaging in legitimate advocacy, even if the positions that are advanced in that advice or in that advocacy are viewed as discriminatory by some. That the rule tries to kind of carve that out so it does not necessarily infringe on a person's free exercise of their religion. And so that's where, once again, kind of the food for thought from this particular concern, this constitutional concern, is that any rule that gets drafted, that this committee should consider drafting something, if they're going to draft something that's prohibiting discrimination, you must take into account the impact that it could have on someone's religious activity, on their religious conduct, including potentially carving out from the rule certain conduct that should remain protected. And I think we have some examples of that, both in the language that we have here in North Carolina, kind of on the table for the preamble, as well as the model rules and other jurisdictions. So it is not, I don't think, as large of an issue as viewpoint discrimination or vagueness or so forth, but I do think it is still a legitimate concern that this committee should keep in mind as they go through the evaluation of this particular issue. So the last thing, that's kind of the overview. I know we've been at it for an hour now, and we wanted to reserve the latter part of this meeting for discussion and questions and any sort of additional research that you all would like us to do, or other things that we should address. But I wanted to let you know about some pending litigation that's going on right now. Interestingly enough, to our I guess as far as our research showed, we did not find any active challenges against these anti-discrimination languages before really this year. There were, I think, we see these different challenges to 8.4D or other provisions of the rules, but there weren't any, at least again, to our knowledge and to our research, that made their way up to have actually published opinions. But we do have some action now. I mean, just last month, we had somebody over in Pennsylvania, a lawyer, filed a lawsuit against a variety of Pennsylvania disciplinary officials associated with the regulation of their profession, seeking declaratory and injunctive relief regarding the newly adopted 8.4G in Pennsylvania. Now, they adopted a version. It's not Model Rule 8.4G, but they adopted kind of their own variation of this anti-discrimination language. That specifically prohibits discriminatory and harassing conduct on the basis of these different specified classes. And a lawyer has filed for injunctive relief and declaratory relief, holding that it is facially unconstitutional. That was just filed early part of August. I am not aware of an answer being filed at this point, but we are going to continue to monitor that because I think that's of particular note for this subcommittee. The other thing was that just about, you can see about 5 days later, an individual out in California filed a lawsuit against the State Bar of California. This individual was presented with a notice of disciplinary charges, and when they were unable to resolve the disciplinary matter by consent, then before California filed their formal charges to initiate a disciplinary proceeding, this lawyer sued the California State Bar seeking injunctive relief and declaratory relief regarding this notice of disciplinary charges. It's not necessarily California's version of 8.4 that he's challenging. California has a unique structure where they essentially have what's called a business and professions code that under which the State Bar, the Supreme Court can enact their rules of professional conduct. So the challenge is really to that code, but I think it's it still challenges the conduct, or it's addressing the conduct that this particular lawyer was accused of, and that was essentially criticizing the rulings by judges using what I'll just say is very colorful descriptions, and arguably very inappropriate descriptions of the individual and the rulings that were made therein. So,
oh, come on, Brian. He called the judge a succubus. Come on.
you can say it.
We're all friends here.
Yeah. But yeah, so that's where California is. This one, again, it's fresh. I don't know that a response has been filed, but we have two different actions in the country right now that are challenging these, at least one in Pennsylvania challenging this direct type of rule, but then California also challenging just the general notion of disciplining somebody for what they said, something negative they said about a court's ruling and the court itself. So we're going to keep our eye on that. We're going to monitor that and bring you updates as we receive them. Certainly think they would be worthy of consideration here as we engage in our efforts. So with that said, Steve, we are that kind of concludes our presentation, and we wanted to open it up for discussion and just kind of start. I guess answering questions or maybe proposing questions and get some conversation going.
Brian, you referred to some comments that have been received that were against such a proposal. And I'm just curious, I've read the materials, but I'm just curious if you could, is there a general theme that as far as one or two things or three things, reasons that people would oppose such a proposal? I mean, it seems to me that a proposal is the right thing to do. We're leaders in the profession and we should be thinking about such a thing. What are the arguments against?
So yeah, the arguments that I've heard thus far, and they've all been, I'd say that the folks that have submitted their comments are really kind of addressing the broad picture that we're looking at right now. The three different proposals, whether it was, and these comments were received before our July ethics meeting, as well as after that ethics meeting. So some of them were just kind of addressing broadly the proposal for a preamble amendment, as well as the proposed amendment to the actual rules of professional conduct and the implicit bias comment. Now we are getting some more specific comments to the preamble, since that is officially on the table. But generally speaking, the comments are focused on freedom of speech, viewpoint discrimination, that essentially this that any type of rule that would I guess cause professional discipline to be imposed against an attorney based upon what the person says that is not considered politically correct would be an infringement on their freedom of speech, and certainly, I mean, I guess having that sort of harm of taking away your livelihood based upon saying something that others don't find either agreeable or they find offensive or what have you, that they don't think that's an appropriate thing for the rules of professional conduct to address. So, and I have not provided all the different comments to you all. I know you all have, some of you have probably received some letters from individuals. There were some included in the ethics committee agenda in July. All the comments that I've received regarding the preamble are going to be included in the ethics committee agenda in October. But I will tell you that I kind of intentionally did not provide the barrage over 80 different responses that I've received. And like I said, it's both in support and against of these different proposals, because I felt like we need to start off by looking at this more so objectively and addressing, and like I said, learning from those comments that have been submitted, what are the concerns? And some of them really are, kind of tough concerns as we talked about here, viewpoint and content discrimination. I don't know that based upon our research that they are insurmountable concerns, but they are still concerns that we must be mindful of. And I think that's a part of this discussion and this exercise to see, are they insurmountable concerns? And if they are not, then exactly what needs to be done to address those.
And if I may, Brian, I think also in answer to your question, Alan, from what I saw, there was significant handful of comments in opposition that were apparently grounded in free exercise concerns, but that were certainly focused on LGBTQ status and gender identity status, and apparently the belief that being prohibited from discriminating against people in those groups would somehow undermine the exercise of faith. That's definitely a theme.
Well, then if if this committee satisfies itself that there are no constitutional impediments to such a proposal that we can agree on, then I mean, it seems to me it's the right thing to do. We're leaders of the profession. We have to understand the times, and I mean, it's if we satisfy ourselves that we can sort of address these constitutional issues, and we don't see the problem, I think that proposal is certainly the way to go.
Let me just say, I did not acknowledge in my opening welcome the really talented, we're just blessed to have really talented ethics experts at the North Carolina State Bar. I saw Alice earlier. I don't see her on my screen now, but she, as far as I'm concerned, is the GOAT of ethics has taught me so much over these years. Brian and Carmen have done excellent work, and I've been pleased to work with them on other committees. Nicole and I have solved a few problems with the help of subcommittees on many issues, and we're fortunate to have all of these people with us. And again, I want to welcome Liza Foley to the fold. And I know you've probably done a lot of late night work in getting all this together, but I think that was an excellent presentation. I feel like I'm leaving a con law class in law school, wondering what to read next and how to figure out where we've just been. But I want to thank you, Alan, for your comments, and I want to open it up to the rest of the group. Clearly, on race discrimination, the Chief Justice has spoken recently, and we have all, I think, been thinking about issues of fairness in our courts. And at the bar, what are exactly the problems? That's one thing I want to know. I think I am lucky to practice where I do in Guilford County. We have an excellent bar. I know many of you probably feel the same about the county that you practice in. I can't say that I personally have witnessed these things, but I know that women in our profession have told me told me anecdotally what sorts of discrimination they may have felt that an old white guy like me wouldn't necessarily. So, in terms of race and gender and LGBTQ, what are the issues that are out there, and what is the problem that we're trying to solve? That's a question that I would like to explore as we go on with our educational approach here. Brian and I when we talked, we had initially had many items on the agenda for today. And then as they got into it, Brian said, well, wait a minute, maybe we better, there's a lot here to chew, and maybe we better confine our first session to the constitutional issues. So that's where we're kicking it off. And I want to open it up for the rest of the committee members to ask questions and give comments at this time.
Steve, I see Colin has his hand up.
Brian and Carmen or Steve, y'all can correct me if I'm wrong, but it seemed like that efficiently defined so that a person would be on notice that their conduct might be in violation of a rule. And maybe that's an oversimplistic review of it, but that seemed to be at least some of the focus from what I got, the lack of specificity about that.
Yeah, I think that's been some of the primary feedback has been the lack of specificity, not just in the different classes that have been articulated, but also in the exactly what constitutes discrimination, what actually would be harassment. Is it somebody being offended by an off-the-cuff remark, or is it actual conduct, discriminatory conduct that would rise to the level of, say, a violation of Title VII. Exactly where in that kind of spectrum of conduct does this fall? But yes, I think the specificity really ranged from the classes themselves to the conduct that was supposed to be addressed.
And Colin, I think that may very well be one of the concerns in my mind. Defining the groups who against whom discrimination is prohibited is probably the least challenging part. I think it is the more subjective terms that Brian just referenced where we would have real challenge. And that's one of the things about the way jurisdictions have approached this issue is, the model rule is essentially just inspiration, and the rest goes to the drafting of the individual jurisdiction, allowing for a lot of depth in defining terms and creating parameters and exceptions and however we want to do it. So I think that will be a huge part of sort of the second stage of this subcommittee's work.
Let me just add that I think as far as feedback right now, whether engaging in a conversation about what exactly is this rule seeking to prohibit, also if there are kind of gaps in our understanding of the constitutional framework that you all have seen, that you all would like explored. We as your staff council want to be able to provide you with the information that you need to make this decision. So if there is anything of that nature, feel free to bring that up now as well. Or you can always shoot us an email after the fact. But I'll tell you, just kind of moving past this, like we said at the outset, we wanted to focus on the constitutional concerns and the considerations that we would need to evaluate in looking at this type of proposal for anti-discrimination language. But then the next step would be looking at these different disciplinary concerns. How have other states drafted their rules? How have those been interpreted? How have they been enforced? Kind of understanding the state bar's process, the Office of Counsel's role in this, and trying to see just, how would a rule, it's kind of that thing I remember Tom Lunsford had said at one point, you only adopt a rule if you plan to enforce it. And so if this is going to be a rule, there's going to be questions about enforcement that we need to explore. And there, like I said before, there's a number of cases that we can look at as well. So that's going to be the next stage. That's kind of coming up.
Hey, Brian, I think Dorothy has her hand up.
Dorothy, yes.
Oh, I just wanted to just make a few points. One, I appreciate the presentation that was made today. I'm quite overwhelmed too, feeling like I'm back in law school in a con law class, but it's well needed. But I want to try to address just somewhat, what the question about what kind of behavior is actually taking place and what things are happening. I think the things that are happening are everything that you can think of. Discrimination against women, as it relates to, how we're dressed in court, our appearance, women get more scrutinized on appearance than men, I believe. Black and brown attorneys are feeling discriminated against or suffering from discrimination just based on being Black and brown. And in all the ways that you can think of, in the general public and, everyday life, that's happening in the courtroom, in the courthouses, in, different, whatever legal proceedings that may go on. And I could go on, but, the LGBTQ, and I know there's more that I'm missing in that list, but all of those folks are feeling discrimination in all the ways that you can think of too, and just that's happening in the general public. And I say all that to say that it's very telling to me that folks are asking the question of, you know, what is it that's happening that you all feel like you need to create a rule like this, or, you know, cause some sanctions that could possibly happen or whatever. I think it's telling because it seems like people really do know. And like you said, I want to know exactly what is it that you're trying to prohibit so I can make sure that what I'm doing is or isn't that. So I think just by that question being posed is the very reason why we need something like this. That if people feel like maybe I am partaking in this kind of behavior that may need to be regulated in some sense, that's exactly the reason why we need something like this. And this discrimination that is happening, or whatever that is happening, it is happening so much and in a way that it's not just something that happens in the courtroom one day or something, but it changes the way a person feels, and it changes the way they are able to interact and be in this profession. And I'm speaking on that as it relates to being a lawyer in these different groups and being in the courthouses and these different proceedings. But just add to that a client or a person from the general public that's feeling that may not have all the resources that we have available to us to be able to help deal with all of those different forms of discrimination and different things. So I just wanted to say that, to say, you know, all of that, but to also point out that I hope that we are not swayed by these kind of questions early on and make us to consider not moving forward. I think that we should continue to take a very strong stance in this regard. I think it's very necessary. I think we all agree that it's necessary in some way. And so I hope that we're not swayed by these questions early on and cause us to you know, get off track and say, well, it's too much work to try to get something like this implemented, so we shouldn't do it. From what I understand, that's what happened the first time go around when this was presented, or something like this was presented. And so I just wanted to just make those notes.
Thank you, Dorothy.
I see Mac, you have your hand up.
Yes, thank you. I have a comment to pick up on what Dorothy, it's actually a suggestion and then a request. There is an article in the fall edition of the State Bar Journal by Judge Ashley Parker Dunstan that chronicles a number of the kinds of things, the kinds of discrimination that occur to minority attorneys, specifically African-American women. I would recommend that article to everybody on this subcommittee. It will make the issue real for you. The second thing I have is a request, Brian and Carmen. The North Carolina Dispute Resolution Commission has proposed an amendment to Rule 9, which basically says a mediator shall not engage in unlawful discriminatory behavior during mediation, and goes through a few other specifics about that. That rule is open for comment until September 16th. Would y'all be willing to touch base with the Dispute Resolution Commission and see what comments they got?
Absolutely.
Absolutely. Yeah.
It's a great idea. Thank you, Mac.
Thanks, Mac. I want to double back on Mac's observation of Judge Dunstan's column. I believe most of those incidents, I haven't read it for a few weeks, but were addressed from the bench to the bar. Is that right, Mac, as you recall?
It was a history of experiences that she had personally had from her early days as an attorney through her days as a judge. So it is all of the opportunities for people to have said or done discriminatory things toward her.
Okay, what I was thinking about was anecdotes that she had gathered from other members of the bar who had been discriminated against. But what we're talking, I mean, we don't regulate judges. Is that right, Brian? Or
That's
judges'
correct.
judicial conduct. So what we're talking about is members of the bar, the conduct of members of the bar toward one another, toward the bench, toward the public. And so I think I just want to make that distinction to the extent that Judge Dunstan was coming from the bench perspective, that we're coming from a slightly different perspective, but it's all discrimination. There is discrimination that has gone on, and I didn't mean to, just by asking the question, what is the conduct we want to remedy, didn't mean to imply that there isn't conduct that this rule may be necessary to effectively address, but that I think an exploration of what that is and the scope of it, to me, would be helpful.
I wonder if there is a way that we could actually solicit specific anecdotes. I mean, I really do think grounding all of this in life experiences would be very important. And we can explore, talk about how we might do that in a way that is, either anonymous or anonymized, so that people may feel more comfortable. But I think trying to compile some specific examples would be very helpful, not only in understanding what we're talking about, but also in when we get to the stage of talking about, what would be prohibited and what wouldn't, how much can be addressed by a rule. So knowing what is actually happening would be helpful. So we'll look into that before the next meeting.
And that is, just to be clear, that is Judge Dunstan's article in the most recent version of the journal. She has a collection of anonymous experiences that the number of lawyers provided her from their different positions, whether they were in the ADA's office or private practice or what have you. But that is in the current version of the journal, or excuse me, the current edition of the journal for everyone's review.
Unless let me just ask, are there any more comments or anything anyone wants to share before we adjourn this meeting?
I don't see any hands up. So
Okay.
no. I think, Steve, if it's all right with you, then we are going to, like we said, we're kind of starting out on this journey of educating ourselves on the different kind of the kind of more objective framework questions, constitutional, disciplinary, enforcement, and observing what other states have done, so we can kind of build any decision upon a kind of what I will hope will just be a solid mountain of information. So we will plan to schedule another meeting, perhaps in the near future. Steve, I don't know if you have a preference. Maybe you and I can talk online or offline about the next time that we can meet. But we certainly do have time that we could potentially meet before the next October State Bar Council meeting, if that's going to work for everyone's schedule or what have you. But we'll talk about that, and we'll get in touch with all the other subcommittee members on the next scheduled meeting.
Well, I agree with Dorothy that this is not something we should abandon lightly, and we want to go forward with whatever number of meetings it takes. And I would love to get together again, if it's the committee's wish, to do it before the next bar meeting in October, have our second session, and get into further education about what other states are doing. Sometime after the 8th would work for me in October, but we can nail down a date. Thank you again, everyone, for an excellent meeting, and thank you, Brian, and all the staff.
Thank you, everyone.
Thank
Thank
you.
you. Everyone have a good day.